The defense lawyer refuses. He refuses to make opening arguments at the very beginning of your medical malpractice trial. Can he do that? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney, and the answer is yes, he can. However, you should know that this is very, very rarely done. It's a very risky strategy, and I'm going to explain why attorneys very rarely use this. So let's say, for example, this is a medical malpractice case. Now, you brought a lawsuit against your doctor claiming that, number one, he was careless, number two, that his carelessness was a cause of your injury. Remember, it doesn't have to be the cause, it only has to be a cause, because there could be multiple causes, and number three, that your injuries are significant or permanent. And now, a medical expert has confirmed each one of those elements in order to confirm that you have a valid case. So now you go ahead and bring a lawsuit against your doctor. The doctor turns around and says, hey, your case is full of baloney. Why are you suing me? I did nothing wrong. That's his first argument. He says, I did nothing wrong. The second argument he raises is that if I did something wrong, so did you, Mrs. Patient. That's the second defense that he raises. Then he turns around and says, you know what? If I did something wrong, whatever I did not cause or contribute to your injuries. That's the third argument. That's the third defense that he raises. Then he turns around and says, you know what? If I did something wrong, and you did something wrong, and whatever I did caused you harm, your injuries are really not as bad as you claim them to be. That's the fourth defense that we see in these medical malpractice cases. So now, the defense refuses to negotiate. The defense refuses to acknowledge they did anything wrong. They are never going to settle this case with you. Instead, they tell you, you know what? We're going to take this case to trial. Let a jury make a decision about whether you, Mrs. Patient, are more likely right than wrong that what you are claiming is true. So now you know you won't get an answer until your case goes to trial. In New York, the typical length of time it takes to go from the start of your lawsuit until the time of trial is anywhere from 2 to 3 years. You have the discovery phase, and then you have to wait until your case approaches trial. So you've got a long time before your case ever gets to trial. So now, let's say you've gone the distance. You've gone through the entire litigation process, and now you have finally gotten to trial. Well, first, your attorneys have to go pick a jury. Once a jury has been selected, and now the judge goes ahead and gives preliminary instructions to the jury about what they can expect and what will happen during the course of the trial, now it's time for your attorney to get up and give his opening arguments. Your attorney has to give opening arguments, and within it, he has to give certain elements of law in order to make out what's called a prima facie case. So what does that mean? It means we have to go ahead and explain to the jury what was done wrong, why we're here, what should have been done, why, if things had been done correctly, you would not have suffered these injuries. And we have to show to the jury during our opening remarks that, listen, none of this would have happened if your doctor was not careless. And all of these statements, all of these comments are going to be supported by our various medical experts who are going to come in and testify that this is absolutely correct, that we are more likely right than wrong, that this is exactly what should have been done, that this is what should not have been done, that here are the injuries you received because of what your doctor did wrong. And now we can go ahead and explain to the jury what all of your injuries are. So we have to create a story for the jury. We have to let them understand and be able to explain clearly how it was that the doctor violated the basic standards of medical care. And now we have to explain to the jury how that improper care, those departures from good and accepted medical care, caused you harm and injury, and how those injuries are significant and disabling and permanent. And all of those things have to be explained to the jury in our opening arguments. Now, why is that? I'll tell you why. It's because you, the injured patient, have brought a lawsuit against your doctor. The law says that since you are the one bringing the lawsuit against your doctor, you have to show to the jury that you are more likely right than wrong. In law, we say that the plaintiff, the person bringing the lawsuit, has the burden of proof. And what does that mean? It simply means that you have an obligation to show to the jury that you're entitled to a verdict in your favor, that you are slightly more likely right than wrong. That's what we have to show to the jury during opening arguments. The defense attorney can turn around as a strategy and say, Your Honor, at this time, I choose to reserve my right to make opening arguments. Now, what does that mean? It means that the attorney is going to wait He's going to wait until your lawyer, the plaintiff's attorney, has put on all of your proof, has put on all of your evidence, all of your testimony. And now he's going to cross-examine each one of the witnesses you put on, no doubt about that. But he's not going to put on any evidence of his own. He's not going to address the jury formally. Instead, he's going to attack the credibility of each and every witness that you and your attorney put on. That's a strategy that he could use. It's a very risky strategy, but it's one he's going to use. And why do I say it's risky? It's risky because at this point, the jury is only hearing one side of the story, according to the defense. They're only hearing the viewpoint of you and your attorney. They're only hearing witnesses that are favorable to you and your case. So for however many witnesses, however many days or weeks it takes to present all of that testimony and evidence, the jury is only hearing one side. The defense lawyer is still trying to ruin the credibility of each witness that gets up there during cross-examination. But the defense attorney still doesn't have an opportunity to explain to the jury why he believes that our case is full of baloney, why we don't have a valid and meritorious case. So instead, he's going to wait. Now, the defense attorney does not have an obligation to put on any evidence. They don't have an obligation to put on any testimony or even to make opening arguments. They don't have any obligation whatsoever. So the defense attorney could literally stand up after your attorney makes opening arguments, and now the judge turns around and says, "Defense counselor, you may begin." And he stands up and he says, "Your Honor, at this time, I reserve my right to make opening arguments until after the plaintiff has rested." And what that means is that he's now going to wait until your attorney has put on all the testimony, all the evidence, all the proof in order to try and prove your case. And why is he going to wait? Because he thinks your case is weak, and now he's going to do two things. Immediately after your attorney has made his own opening arguments, he's going to jump up out of his seat and say, "Your Honor, at this time, I ask that you dismiss this patient's case because they have failed to make out a prima facie case in opening arguments. They have failed to lay out the elements necessary in order to show that they have a valid case just based on the opening arguments." Now, I will tell you that there have been some instances that I'm aware of where a judge has actually thrown out a case after opening arguments have been made. Now, that's tragic and that's unfortunate. That should rarely, if ever, happen. Why? Because when you're going to trial, you have to have all your information, you have to have all your proof, you have to have all your experts lined up. And now there should be no excuse why an attorney's case should be dismissed after opening arguments. Because an experienced attorney should be able to fashion an argument that explains to the jury exactly what was done wrong, why these things should not have happened, what should have occurred instead, why this patient never would have received these injuries, and be able to lay out a case to explain to them in simple, easy to understand language that this never should have happened. And to make out this prima facie case, which is Latin phrase for basically showing the elements necessary that you're entitled to a verdict, which really is nothing more than showing, number one, that there was wrongdoing. Number two, we call that liability. Number two, that the wrongdoing was a cause of your injury. Remember, there has to be that link, that bridge between the wrongdoing and your injury. We call that proximate cause or causation. And then there has to be damages. So we have three elements: liability, causation, and damages. And if an attorney fails to do that, fails to explain to the jury during opening arguments all of those things in his openings, guess what? Then the defense attorney would be absolutely right to ask the judge to throw out the case because he failed to make out a proper case on opening arguments. And the judge would be well within his right to turn around and say, "Plaintiff's attorney, I'm sorry, but he's absolutely right. Your case is now dismissed." So the defense attorney is hoping that your case gets dismissed after opening remarks. But that is rarely seen. The defense attorney is hoping that at the end of your case, after all the testimony and evidence have been put on, that it's insufficient to get to the next stage, which would be to let it go to the jury, to let the jury decide whether or not they are more likely right than wrong. So what's he going to do? Well, assuming this strategy is used, where the defense lawyer says, "Hey, you know what? I'm going to wait and hold off making my opening arguments until after you, the injured patient, has put on all of your proof." At the very end of your proof and your testimony, your attorney stands up and says, "Your Honor, at this time, the plaintiff rests." Now, what does that mean? It means that your lawyer is telling the judge that he has no more proof, no more evidence, no more testimony to put on to support their case. They're done. And now they're hoping that the judge will allow their case to go to the jury so the jury can make a decision about whether or not they're entitled to a verdict in their favor. But now, before anything else happens, when the judge turns to the defense lawyer and says, "Counselor, you wanted to wait until the end of plaintiff's case in order to make your opening remarks? Go ahead, counselor." The defense attorney now gets up and says, "Your Honor, before I make opening arguments or before I even decide to make opening arguments, I ask that you dismiss this patient's case for the following reasons. Number one, they have failed to make out a prima facie case. Number two, there are no questions of fact to be decided here, only questions of law. Number three, I ask that you dismiss this case as a matter of law for the failure to state a cause of action." Those are three typical options that we're going to see when this strategy is employed. The defense lawyer is now going to do everything possible to get your case dismissed and thrown out of court before the jury ever sees it, before the jury ever gets a chance to make a decision about whether or not you're entitled to a verdict. And he's going to throw every possible legal issue and legal objection in front of the judge so that the judge can hopefully agree with him on at least one of those points. And if, for whatever reason, the judge does agree and throws out your case, you get zero, you get nothing. Out of all the years you spent waiting and litigating your case, the jury never even gets to consider whether you are entitled to a verdict and money in your favor. That's amazing. So now here's what happens. So now the judge has to consider immediately whether or not the defense lawyer is right. And he has to decide, hey, listen, is there a question of fact? Well, imagine this scenario. The patient says the doctor was careless for the following reasons. The doctor says, no, I wasn't, for the following reasons. Do you think that's a question of fact that has to be evaluated and decided by the jury? In most instances, the answer is yes. There are clear disputes. The doctor says one thing, I did tell the patient. The patient says, no, she didn't. The judge can turn around and say, you know what? There are questions of fact, which means this case is going to a jury, and now, counselor, you better decide whether or not you're making opening arguments. If not, I'm going to put this case in front of the jury right away. So that's what could happen. On the other hand, the judge could decide, you know what? There are no questions of fact. There are merely issues of law to be decided by whom? By the judge. For example, if the patient did not bring this lawsuit within the appropriate time period, now the defense could turn around and raise a legal argument and say, Judge, this case was never brought in a timely manner. And because of that, we now ask you to dismiss this case as a matter of law. And the judge has to seriously look at that argument to see whether or not it's true. He also has to look to see why wasn't this argument made early on in the case, at the very beginning of the case, or throughout the duration of the case. Why is this only being made in the middle of trial? That's a very interesting question. And it may not help the defense attorney that he's only making this argument during the middle of trial. He may say, listen, you waived your right to bring up this issue at the very beginning or during the middle. And because you waited, I'm not even going to consider that. I'm going to deem it waived. So you cannot bring up that issue anymore. That's a possibility. So there are lots of options that can occur, lots of possibilities. And the whole purpose of using this type of strategy is that the defense lawyer is hoping, he's hoping that the judge is going to pick one of them in order to dismiss your case. So now, let's say the judge says, no, defense counselor, I don't agree with any of your arguments. Now, are you making opening arguments or not? In all likelihood, the judge is going to deny most, if not all, of the claims that he's raised, the defenses. And now he's going to tell him, listen, open or not? And the defense lawyer, what's he going to do? You better believe he's going to make an opening remark. He's going to make opening arguments. Why? Because he doesn't want to give up that opportunity. He chose from a strategic standpoint to push that off until the end of all of your proof. He was hoping upon hope that your case would be dismissed after opening argument by your attorney. Then when that didn't work, he was hoping that your case would be dismissed after all of your proof was put on. And when that didn't work, he now is not going to turn around and remain silent and just sit there. And he's not going to sit there silently hoping that the jury can read his mind. That doesn't work that way. Instead, he's now going to get up and begin his opening arguments. Ladies and gentlemen, I am the defense attorney in this case representing Dr. Jones. And we believe that this case has no merit whatsoever. And now he's going to go ahead and explain why they believe that there's no merit to this case. He's now going to explain to the jury what medical experts they are going to bring in to support their position that nothing was done wrong. And that even if something was done wrong, it didn't cause or contribute to this patient's injuries. And their medical experts are going to testify that your injuries are not as bad as you claim them to be. So let's go back to the very beginning, the title of this particular video. The defense attorney refuses to make opening arguments at the very beginning of your trial. Can he do that? As I mentioned, the answer is yes, he can. But it is a very, very risky strategy, because now you're waiting and waiting and waiting days, even weeks, before the jury hears from you as to what your real position is. All they've heard at this point is you cross-examining various witnesses. And while the jury may get hints of what exactly it is that you're claiming, what the defenses are, they don't truly know yet. Why? Because you never made your opening arguments. The defense lawyer did not present an outline of exactly what it was he was going to be claiming, and what the defenses were, and what experts and what witnesses were coming in to testify on their behalf. Can it work? The answer is yes, it could work. It's a risky strategy, and very, very few defense lawyers are willing to use it. But there are certain instances where it can occur. So why do I take the time to share this great information with you? I wanted you to understand how these types of medical malpractice cases work here in New York. And you know, I realize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York, and you have not yet started a lawsuit because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a fantastic day.